Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Cause number M330166 and cause number M330168. Both cases are filed in the state of Texas versus Victor Felipe Leon. Mr. Leon, is that your full name?
Yes, sir.
Mr. Leon, would you please raise your right hand? Mr. Leon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Leon, you may put your hand down. Mr. Leon, you're representing your case by your attorney, Attorney Wright Kimler. Attorney Kimler, how are you doing?
Well, Your Honor.
Okay. Mr. Kimler, do you have a record in Mr. Leon's cases?
So,
Mr. Leon, in cause number M330166, I have before me a document that is titled information. In this information, it alleges that you, Victor Felipe Leon, on or about April 18 of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Leon, do you understand what you've been charged with? And to this charge, Mr. Leon, how do you plead? Guilty, not guilty, no contest?
guilty.
Now, are you pleading guilty? Now, are you pleading guilty because you are guilty?
Yes.
And are you pleading? Now, Mr. Leon, I also have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit number 1. Mr. Leon, do you recognize this document?
Yes.
You have it in the wrong spot. Does it?
What's that?
You have checked the wrong box. Yeah. Yeah, this is a driving while intoxicated with alcohol concentration level 1.5 or more. You checked the wrong box.
It's the third. She rated the third.
Yeah, I mean, that doesn't change the offense.
Oh, you're talking about the admonishment?
Mm-hmm.
I'm sorry. I thought I hit that DWI first.
Yeah, you had a DWI first, but I mean, but the information says this is driving while intoxicated with an alcohol concentration level of 1.5 or more. That's a class A misdemeanor.
You could be, I think.
I think, is it a B with an enhanced punishment, or is it an A in and of itself?
It's an A in and of itself. Here you go. You checked the wrong box.
Let's put that in.
I'll let you do that.
Well,
Oh, that's the one that's not erasing. There's one of them that don't erase.
I scratched it out of this one.
Yeah, it don't erase. Okay, now, Mr. Leon, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. You recognize this document?
Yes.
On page 2 of the same document, there's a set of initials, VL, on the line that's next to a box that says check. Guilty. Did you place your initials on this document?
Yes.
On third page of the same document, there's a signature above the line that's titled defendant. And is that your signature?
Yes.
The next document is titled trial court certification, the defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
I also have before me a document that is titled discovery certification. Recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Leon, before you signed any initial these documents, did you read the documents? And did your attorney go over these documents with you?
Yes, sir.
You understand everything in these documents?
That's correct.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Leon, are you a citizen of the United States?
Yes.
State, I have before me States Exhibits 1, the misdemeanor plea admonishment. And State, would you like to offer States Exhibit number 1?
Yes, Your Honor.
No objection.
No objection, States Exhibit number 1 will be admitted. Mr. Kimler, you advised and counseled Mr. Leon. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Leon, your attorney, Mr. Kimler, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Leon, I will accept your plea of guilty. I will find that you're mentally incompetent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond reason without state. Do we have a plea bargain
We do,
agreement?
Your Honor.
What is that agreement?
Okay, in exchange for the defendant's plea of guilty, the state is offered 1 year deferred adjudication, 80 hours community service, $500 fine, and interlock and dismissal of M330166. Wait a minute, let me show. Okay, dismissal of M330168. That's the resisting arrest.
What is the
Fine amount, $500.
there's $500 fine plus court costs
Mhm.
and community service of how many hours?
80
80
and an interlock.
and an interlock,
Mhm.
That's correct, Your Honor.
interlock and drug and alcohol.
Send it.
Okay. I think it's.
Just something.
I'll throw one out. It's already-
Yeah.
It's up there with the.
Now, in this here, when it says, the state is offering 1 year deferred adjudicated probation. In this case, he has a DWI, an alcohol concentration, it's class A misdemeanor alcohol concentration level of 1.5 or more, pursuant to Article 42.102, Section B1. I don't think he's eligible for the deferred. Okay. Yeah, under that section.
Okay, that's an offer that the state made to defendants.
Well, I understand. I mean, but the court doesn't have an authority to give him deferred under that statute.
I think he's
The way, yeah. I mean, you can take a chance and look at it. It's 42.8.102, Section B1B.
not ready to be.
B1B. Yeah.
I ready to be there at the discretion of the state, Your Honor.
Okay, I'm just reading the statute as it is written, the plain language of the statute.
Okay, well, I believe a few cases are on hold now. due
Yeah,
to
but
this.
those, yeah, but I think they was played a different way.
How would they be pledged that would make? it?
I can't tell you, but I'm just saying this, the way this case is. But I mean, right now, we just got an issue that the court is looking at. That's
If we
being,
If we
it's
kept-
being briefed and, also, not only is it being briefed by the
It is.
defense, I think the state, I don't know if the state is briefing as well, but the court is also briefing it.
When is there?
I think I want to say that it's mid-October, I think, when the brief is due, if I'm not mistaken.
I don't know, you can get your plea back if you don't want to do the fire, you can just try the case. You want to try the case? Okay, wait, if he wants to withdraw the plea, we have something.
Okay, so he'll be, huh?
I thought I'm deferred on.
That was-
I understand. I mean, if you have, the court is not following the plea, you're entitled to withdraw your plea.
And that's what we offered. It's out of line.
Okay.
That's how it-
Okay, you're entitled to withdraw your plea.
Thanks.
Okay. So actually, he goes up, he's number one then.
Okay,
Okay.
all right. I'm trying to hear things.
And so what's the next case?
Nep is.
Nep? Yeah, we don't need it. Nep, Mr. Nep, we're not gonna, yeah, we gotta cancel that. We're gonna try it. It's gonna be a trial. I'm gonna go ahead on and just. This is Nep, it says Nep, did they send Nep to us?
Well, you know.
Okay. On Nep, okay. Nep, that's the plea?
Well, if this question on the third, I think the hold up on getting the third, and that would be. The opinion,
Was straight.
I know you offer it, but he may get the third, he holds it for the third next time. What's the?
I mean, that's up to the state to offer it.
He'd have the ability to offer it. Next time, obviously, something.
Okay, so let's go ahead on and get Mr. Leon, just go ahead and get Leon ready
Right.
and get the jury in on Leon. But while you were out in the hall, we were conducting business in the courtroom, and you could not be present while the business was being conducted. That's why you had to wait outside in the hallway. You have been called to jury duty this week to serve on a criminal case. Our courtroom hours are normally from 9 a.m. to 5 p.m. However, in this court, we usually have a large docket in the morning, which starts at 9 a.m. and sometimes we go to 12, and so a lot of times we go past 12 o'clock. When we start at 9, we go past 12 o'clock. And so what we've been doing, we've been having our trial start at 1:30. So today we'll pick a jury, and then tomorrow we will start testimony in this case at 1:30 on tomorrow. Whether or not you're selected to serve as a juror in this case, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate at recess, for meals, and at night. Now, I would be remiss if I didn't tell you that I'm Judge Terrence Holmes, who's the presiding judge here in this case. Now, I must administer the first of 2 oaths. So at this time, I need every one of you to raise your right hand. And then once I finish administering the first oath, I will need everyone to please say, "I do." Do you and each of you do solemnly swear that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover that this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, at this time, those individuals who are waiting for their cases to start, since this case is going, you are excused. Everyone on the back row. Now, the way I'm going to ask the questions, I'm going to ask a series of questions. I do not want you to answer the questions out loud. I just need you to answer the questions to yourself. And then once I finish asking this series of questions, then I will ask, is anyone disqualified under the law? And if you think that you are disqualified under the law based on the way you've answered the questions, then I will ask that you will come up before the court so that we can discuss the matter more privately. And when I mean more privately, I will turn off the microphone and turn on the sound noise device so that we can discuss the matter more privately. Now, I will start off with the first question. Except for failure to register, are you a qualified voter in this county and state under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I have to ask this question. I'm not trying to meddle into your personal affairs, but it's just a question that's required. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of the state of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. No one has raised their right hand, so everyone is qualified under the law. Now, I would determine if anyone is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. Now, if any of these applies to you, but you still desire to consider or be considered as a juror, you will just remain seated. And I will ask the questions in the same manner that I asked the first set of questions. I would ask a series of questions, and then at the end, I will ask if anyone feels as though, or if there's anyone who would like to claim an exemption. First question. Are you over 70 years of age? Do you have legal custody of a child or children under the age of 12, and jury service will necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding this date? Are you the primary caretaker of an invalid who is unable to care for himself or herself? Are you a member of United States military forces serving on active duty and deployed away from your home station and out of Jefferson County? Is there anyone here who would like to claim an exemption? Okay, we have 2 people. Okay. Yeah, turn switch up. Come on up. Yes, they claim. Okay, we have juror number 13 and juror number 12. Who's claiming an exemption. Juror number 13 is Nalicia and Maldonado. Would you please come forward? Now we'll move on to exemptions. At this point, if any one of you feel as though you cannot sit as a juror, when I finish making these statements, rather, just please raise your hand when I ask if anyone would like to claim an excuse. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the district attorney's office and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? If you would like to claim an excuse, please raise your right hand. Let the record reflect that no one is claiming an excuse, so let the record reflect that all the jurors are qualified. And at this time, we will proceed with our voir dire. Let the record reflect that the time is 3:30 on today's date of August 29th of 2023. The court is in session in cause number M330166, case of style of the state of Texas versus Victor Felipe Leon. Let the record reflect that Mr. Leon is present in court with his attorney, Mr. Wright Kimler. State is present with Assistant District Attorney Erica Porter, who is sitting first chair, and Colby Hoffbauer, who is sitting second chair. Let the record also reflect that our court reporter today is Ms. Ada Christie. Now, Ms. Christie will be taking down everything that is being said. So speak up when you are answering or asking questions. The bailiff in our case is Mr. Charlie Porter. The defendant, Mr. Victor Felipe Leon, stands charged with the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, okay. We need to go.
Yes. You can bring up the resistant. It's two charges. It's the resistant as well as the. It was only dismissal based on the plea, but we didn't go through the plea officers. It's the resistant as well as the driving while intoxicated. We're moving forward on both.
So,
I consolidate.
Yeah,
oh, you filed the
I
motion
did.
to consolidate?
yeah, I was just trying to get that.
In order to make, she filed the motion to consolidate.
I think we got
Hold on a minute. Let me do this here. Mr. Porter, just hold on.
I was.
Just, just hold on.
I was. Really, too, you got it right. I just found this. I was trying to get a job. I just know. Yeah. Yeah.
We'll have to come back.
Oh,
I don't see wood step up, probably outside.
Yes. Yeah, if you're going to. You would have to remove it. If it's not happening, well, he would have to.
Yeah.
Okay, but it's the money.
Yeah.
So you're making an objection based on
Yeah.
consolidation.
Yeah.
we'll just.
Hold on a minute. Okay. What was? Hold on. Okay. Mr. Porter, you can go ahead and get the jury. Oh, we got Mr. Martin.
Yes, sir.
We could get the jury and just have them to sit in their, the same seats. Huh? You got the jury list? You have the yeah, you see 1 through, did he mark on there who's here and who's not here? Yeah, why don't you give it to me?
So I'll just walk in and you said.
Okay. Let the record reflect that we're back in session and calls number M330166. Case of South State of Texas versus Victor Felipe Leon. Let the record reflect that Mr. Leon is present in court with his attorney. Let the record also reflect that the state is present with his assistant district attorneys. And let the record also reflect that the panel is now present in the courtroom. Ladies and gentlemen of the panel, the state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up before the bench so that we can discuss the matter more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defendant ready to proceed? The panel is yours, Ms. Porter. You have 30 minutes.
Good evening, I'm Erica Porter, and I'm an assistant district attorney from Jefferson County. I'm also associate partner, Kobe Hall. He's an assistant district attorney. You already know what this case is about. I'm gonna be moving up in front of this podium. I don't want to stand behind the podium the entire time, so you might see me moving in front of the podium some. And I'm going to need you, everybody in this panel will talk to me. If you don't talk, in my eyes, okay, well, if you're quiet, I have nothing to exclude you by. So you might get picked on this jury. The people that talk, something to go on and base it on it, and then I might not be able to pick for a jury. So silence is not the key today. If you don't want to get picked. We're gonna go through. I want you, everyone to look. There's TVs around the courtroom where you can see. So as I'm talking, you can look at the TVs. The first thing, driving while intoxicated. This case is a DWI case. What is DWI?
In Texas, a person commits the offense of driving while intoxicated if they are intoxicated while operating a motor vehicle in a public place. You might ask, what is intoxicated? There's actually three definitions for intoxicated in Texas. First definition, when you lose the normal use of your mental faculties, and that's due to the introduction of alcohol, drugs, controlled substance, or dangerous drug. Also, you can lose the normal use of your physical faculties, and that's due to the introduction of drugs, alcohol, dangerous drug, or controlled substance. Or if your blood alcohol content is above 0.08. So those are three different definitions, okay? Now, a big misconception in DWI cases is that the individual has to be drunk. That's not what the law says. So what does it have to be? Intoxicated? No. Defendant has to be intoxicated. Intoxicated means not having the normal use of your mental or physical faculties due to the introduction of either alcohol, in this case it's alcohol, drugs, controlled substance, or dangerous drug. We already discussed what intoxicated in Texas means. I'm gonna fly through that slide. Why do we have three definitions of intoxicated in Texas? Okay. So who's seen Revenge of the Nerds? You were old enough to remember that movie. I saw two individuals raise their hands. And I'm gonna make sure I call your name correctly based on this chart. I believe you're Miss Skinner from your last name. Mendoza, okay. So you understand what Louis and Omar, those two characters. Okay, so we're gonna talk a little bit about Louis. He was 145 pounds, right? And he was not a drinker at all. So he didn't drink at all until his wedding night. He had 2 glasses of champagne. His speech became slurred because he's not accustomed to drinking. So after 2 glasses, his speech became slurred. He began to have poor balance. His mental and physical faculties were not normal, but he was not over 0.08. Okay, but he did hit those other elements, mental and physical faculties. Now let's talk about over. He's a career drinker. Okay, so party guy, weighed 250 pounds, champion drinker, drinking since he started shaving at 16 years old. Okay, so he drank 2 or 3 pitchers by himself. Very high tolerance. He didn't lose his mental and physical faculties, however, he's way over 0.08. In this situation, who's intoxicated? Both. And both are intoxicated. Why? Maybe I'm gonna ask you, let me get your name. This is okay.
They both fit criteria in the definition.
Okay, and let me ask, go a little further. If it was just only one criteria, is that enough? Okay. What about you? Do you think it's enough? Okay. How many out of 3, so out of this panel, think that all 3 criteria have to be hit? Anybody? All 3? Okay, so everybody thinks only one has to be hit. So either physical or mental or 0.08, right? Or above. Okay. Everybody knows, typically everyone knows someone has been arrested for DWI. Let me ask you, Mr. Dante, you know anyone that has been arrested for DWI?
Yes.
You have. Okay, not you, someone you know.
Not me.
Okay. And close relative?
No.
Okay. Anyone else know anyone that has been arrested for DWI? Let me get your name. Mr. Jeremy?
Yeah.
Okay, close relative?
No, a friend in grad school.
Oh, grad school, so I think still in college. Okay, all right. So what, anyone that has been hurt, anyone knows anybody hurt or injured by someone that you do? Okay, what is your name?
Let's go with Field.
Mrs. Vicky?
Yeah, so I don't know this Field.
Oh, you know someone with it. Close relative or friend?
Yeah.
I'm sorry to hear that. And so you said it was someone close to you, right? Okay. It affected you.
Yeah. Yes.
Okay, so who's been around someone that has been intoxicated? Everybody. Okay, I'm gonna go down the list. Let's see, Miss Octavia. You've been around anyone that's been intoxicated? And how were they behaving? And when you were around them? Party. And what about you? Have you been around somebody? I'm sorry, Mr. Charles? No, Mr. Williams.
Yes, I have, social environments, different places.
Okay, this is intoxicated, not drunk, this is intoxicated, you've been around someone who's intoxicated.
Also, going back to your first question, thank you, Chief, like you, but I have known, someone that, had a DWI relative.
You did, close one with you. And Charles, what about you, you've been around anyone who's intoxicated? And behavior wise, did you notice any,
Slurred around, stumbling.
those clues, you notice those things? Okay. So how do you know someone is intoxicated? Well, let's see, who have a last one, Jimmy? What's one thing that you, Jimmy, oh, Jimmy, what's one thing that you look at when you? As a-
I mean, they may not be able to walk straight. Or slur.
Okay,
You can also. No,
you smell the alcohol, does it have a distinct odor? Okay, what about you, Mr. Slade? What about you? Okay, what do you notice? What are some of the foods you look
a better time than normal.
at? Almost. Okay. Okay. What about, balance? We got hit on that speech, smell, judgment, and actions. Those are all things that people that are intoxicated, maybe clues you can horn in on, right? Okay. None of these are expertise. It's just common sense. Common sense. What would you like to see in a DWI trial in order to possibly find someone guilty? Mr. John, love it.
Oh, I'd like to see stiffer penalties.
You would.
Oh, yes.
Okay, so what would you like to see presented in a DWI trial, evidence wise?
Oh, just the evidence that shows that they were.
Okay, like what? You have an example? Maybe.
Any one of the three you named a little while ago.
Okay, okay. All right, what about Mr. Brian Mendoza?
I agree.
Yeah. Okay, so- all right, so what about in-car video? Would you like to see some in-car video to show maybe the individual's action?
Sure.
Okay,
Well, I've seen the guy that lived across the street from me. He would get so drunk, he couldn't even pull in his driveway. He would leave his vehicle on the street, lights on, engine running, and fall asleep, and I'd get up and call the cops on him.
oh, okay, okay, Ms. Kayla, what about you? What would you like to see?
Yeah, a video would be helpful, but just the facts, I mean, if they were over 108, if they, were stumbling or any kind of dash cam footage or evidence.
Okay, and body cams, you heard of body cams as well?
Yeah.
Okay, what about that? Would you like to see some body cams if they were out there? Okay. Okay. What about blood tests? Nobody talked about blood tests. Anybody would like to see blood tests? Yes. What about you, Mr. James? None? Mr. James?
Swain, yeah,
Would you like
sure.
to see blood tests?
Blood test, video.
Okay. Testimony, Mr. Jeremy, would you like to hear testimony as evidence?
I'd rather see the blood test.
You would. Okay, okay. And types of witnesses, let's talk about that. So there's eyewitnesses, in case you want to know what eyewitnesses are, somebody that actually visually saw the event. Also police officers. So how do we treat each kind of witness? Every witness is to be treated the same. Okay, no big eyes, little news, every witness is to be treated the same. There's an officer. He's a witness, but officers are not to be given special treatment. They make mistakes like everybody else, right? They're human. They're to be treated the same, okay? Standardized field sobriety test. Everybody heard of that? Okay, let's see if anybody semi knows what that is. Who have I not spoken to? I never have spoken to you. Miss Betty?
Breathalyzer.
Okay, so, brother, that's It's not, but. That's
Oh,
very
in the test that they do for nystagmus.
right, absolutely, that's a part of it. Okay, so they're divided attention tests, and why are they divided attention tests? Because driving requires you to have divided attention. You have to get focus on who's in the next lane, you still have to maintain control of the vehicle. So they are divided attention tests. If someone has to be able to listen to the instructions, give it to him and follow the instructions, right? You're intoxicated, it's a chance you're not gonna be able to do that. Okay. And those are my examples. 2 seconds late on the brakes could mean that you're gonna rear end someone. And also turning the steering wheel 1 inch to the left to make the difference in sideswiping someone. You have to be focused when you're driving. Okay. What's the law? Texas legal limit, 108. Everyone is impaired by definition. They're impaired in their ability to operate a motor vehicle if you're at 0.08 or above blood alcohol. Okay. Now, the defendant doesn't have the burden of proof at all. He doesn't have any burden. It's on me. It's on the state. Let's start as well with code. Subpoena powers, right to discovery, it has all of that. Right to trial, right to not to testify, it doesn't have to say anything. Right to defenses, it's on the state. We have to prove our case. Okay. There is a presumption of innocence. Okay. What does that mean? Tell me one person I'm
Innocent to prove.
innocent until proven guilty. Okay. Everybody agree with that? Everybody has, it means that the state has to prove defendant guilty beyond a reasonable doubt. Okay, reasonable doubt. Let's talk about that. It's not really a textbook definition for that. However, when you see it, you'll know it. It doesn't mean all doubt. It just means that if it's reasonable and you feel like, okay, this is what we met our burden, well then yes. And it's not beyond a shadow of doubt. That's something that's on TV. Okay. CSI. But common sense. All criminal trials in the US, it's not impossible to beat. And it's kind of like that gun puzzle. You see some pieces missing? Everyone sees some pieces missing. Do you have any doubt in your mind what that is? Can anybody say, oh no, this is not a gun? If you see anything other than a gun, just let me know that. It looks like a gun, right? But some pieces are missing. However, you can kind of definitively say, oh yeah, it's a gun. Missing pieces, same as trauma. Certain things might be missing here or there, but it's enough to definitively say, okay, that's a gun. All you need is what? Common sense. Blood alcohol content. So when you're arrested under suspicion for DWI, you're given an opportunity to provide a breath or blood sample. Okay, some people refuse. However, refusal to provide a sample is not a constitutional right. And I'm going to ask the question why, if anyone knows. I want you to raise your hand before I start calling on you. Why is it not a constitutional right to refuse? Okay, I'm gonna call. Let's see, if you're real quiet, I'm really gonna call on you, Mr. 1, 2, 3, Brian, is that over? Okay. You're not sure, anybody can help Brian out? Okay, okay.
It's just one of the many things that the Constitution just doesn't address.
Okay, good answer, but anybody else want to take a stab at it? And I'll call one more person for. Charles, so you don't know, okay? Because driving is a privilege, not a right. So some people have in their head, oh, I have a right to drive. No, it's a privilege. You don't have a right to drive. It's privilege. So with that privilege comes consequences. Your implied consent to either have blood drawn or breathalyzer. That's just something that you impliedly consent to, okay? Every driver agrees to give a breath and blood sample upon an officer's request. It's implied consent. We can't physically compel a person to give a sample without a warrant. However, if they refuse, you'll lose your license for up to 90 days or a year. most importantly, the refuser is evidence that a jury will hear. So you guys will hear that if there is refusal. Does anyone know Victor Leon, the defendant? What about Ryan? Emily? You know me, Erica Porter, you know me. Anyone else know me? You know. I am married to Ken. How do you know Ken? Oh, you work with him. Okay. All right. At mostly. Okay. All right. Anyone else? Know me or my spouse or someone? Okay, so knowing Kenneth, would that prevent you from being able to judge this case based on the law? Okay. What about Kobe? Does anybody know Kobe Hoffa? No one knows him. Okay. Can anyone in here not sit in judgment of another person? Some people just can't. So if you can't, then I need to know now. I know your situation. Anyone else? Okay. We're gonna talk a little bit about past jury duty. Several people in here answered on the questionnaire that you sat on criminal trials before. Some didn't say anything, so I just didn't know what to make of it. Ms. Gilbert, did you have any criminal or any jury trial experience? No. Okay, no. Mr. William Dishman,
Yes,
you sat on a criminal trial before?
I have,
It was how long ago? It was a while.
you know,
Okay, and you reached a verdict in that case?
yes, we did.
Okay. And you assessed punishment as well?
No, they elected to have a judge.
Judge, okay. Okay. All right. What about Mr. Slade, Christie? You sat on a criminal trial before? And did y'all reach a verdict? And did you assess punishment or no? You did, okay. John Levitt? You as well, you sat on a criminal trial before, and y'all reached a verdict, and you assessed punishment as well? Oh, the judge assessed. Okay, well, Graham, you sat on a criminal. You reached a verdict, and you assessed punishment, okay. Right. I believe, no, I have one more. Betty Sala,
Yes,
you sat on a criminal trial before,
yes,
and you reached a verdict.
yes,
And were you able to assess punishment on that case?
yes.
Okay. Okay. So if you're picked on this jury, you're gonna decide the facts, apply the law to the facts, and follow the law. That's your job as a juror. Any questions from me? Now's the time. No question.
I didn't have the opportunity to answer before. My cousin was killed in a drunk driving accident, but he was the drunk driver, so he essentially killed himself. But that was, still well when that happened.
Mr. Jeremy? That's
Yes.
yours? Okay. Did that affect you?
Well, I mean, yeah, I was like 35 years ago.
Oh, thank you. And if that's nothing else, I'm gonna take my seat. Thank you.
Kimler?
Yes, Sean.
May proceed.
It'd be the American flag and what. I think y'all think we're picking people off this panel for the jury, or selecting. One, two, and three, that's what we're doing. Anybody? Just trying to look the jury. We're gonna be doing, we board iron, selection process.
My understanding is that these are 6 jurors, but the first 6 are on the jury, and then you have to eliminate it or process.
Right, process elimination, each side eliminates 3 people off of the ground. And the first 6 people who aren't eliminated by either side, you bring with parental challenges will constitute the jury. So if you do the math, if you do 6 jurors, and each side gets to eliminate 3, well, that's another 6. You go out 12 people, and that's what we call the strike zone. So other things being equal, the first 12 people are where the jury is going to come from. So in the case that we have here, obviously there's more than 12 of you here, which, originally had 20 people called. So we had, let's see, 2 no-shows and 2 excuses, 2 excuse people that were excused once they were here. So 4 people were eliminated off of the first. I'm sorry, 3 people eliminated out of the first 6, well, so that bumps it out to 16. We'll count 16 people, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, so just a slang potential. Everybody here potentially can do it. So all of you have to pay attention. Maybe potentially, be here, sir. Now, obviously, when you're seeking to eliminate people, identify people you're going to eliminate as an attorney, you want to know the people that aren't favorable juror to your side. And in the cases of any kind of intoxicated related offense, what that means is that if someone has had a family member, relative, someone either killed, seriously injured by an intoxicated driver, that obviously is something that may impact their ability to be fair and impartial. And I think, Ms. Dudley, would you indicate that that was the case with you?
Yes.
And do you think that your ability to be fair and impartial?
No, I could not be.
Okay, we'll take that up here in a minute, but I'm sure that the judge will talk to you about that. Right. We won't take that for the whole thing. We'll bring it to the division. Appreciate your honesty. Is there anyone else in Ms. Dudley's position because of their experience? Either, themselves, loved ones, whatever situation with an intoxicated driver, still very injured, who doesn't think they could be a fairly impartial juror and intoxicated driver often. And that doesn't mean you wouldn't be a good juror on a burglary of a vehicle offense or a murder case or something, but just intoxicated driving related. Anybody else? Mr. Holmes indicated that he had a relative who was killed, who was, I guess he had to say, a victim of a drunk driver, unless he's a victim of himself, but does that impact your ability to fair and impartial? What happened to your?
No, in fact, I've served on a DUI jury before.
Okay. All right. And, Ms. Porter's done a good job kind of elaborating what the law is regarding intoxicated driving offenses. There are 3 different ways that you can be intoxicated, not having normal use of your mental or physical faculty. Other reason, introduction of alcohol, blood dangerous medical control substance, or a combination of those in your system. It's not the normal use of mental or physical faculty, and also the separate idea of having blood alcohol content on 0.08 or above. And I believe in this case, there is an allegation that the defendant does have a blood alcohol content of above 0.08. So I anticipate to hear evidence regarding that. Mr. Arnold, I'll just stick with you for a minute. What's your view of scientific evidence, the type of scientific evidence of blood draw?
That's a very broad question. Can you be a little more?
Okay, what standard do you think that you want to stand in that with six well labs and or explanation here? They reach the conclusion of advanced formulator above in the analysis. How detailed of an analysis do you want?
I guess. In detail.
So would you like an explanation of how such sequence with the computer software, how it might be employed or how it might be used or that type of thing? And then also how the instrument that analyzes the blood operates, so it's actually explained to that they were clean and sanitary conditions when the blood draw was taken, all those things, that all those things are important.
Yes.
Everybody, you like disagree? Sorry,
And in chain of custody too.
chain of custody, exactly. Was it refrigerated? If not, why wasn't it refrigerated? Were any added chemicals to it? What were the potentialities of the added chemicals changing the result? All those things. Right? Because at the end of the case, the judge is going to instruct you that you have to believe beyond a reasonable doubt all the elements of the offense. That essentially that it was intoxicated either by the normal use standard or by the 108 standard beyond reasonable doubt. And he's not going to define what beyond reasonable doubt is. It's up to each one of you to determine in your own mind how high the standard that is. Now, Mr. Dishman, how high the standard do you think beyond reasonable doubt is? What do you think?
In my opinion, it's gonna be pretty high.
Okay. How high is pretty high?
Yeah, I'm pretty about it. I guess 65 or 75. Not it's, I would think that I like things higher.
Higher than that.
Based on information.
But do you make decisions in your own life that you think have to be based on beyond a reasonable doubt?
Sure.
What about when you're pulling up to a red light and it turns green, do you want to go through that intersection beyond a reasonable doubt, there's nobody gonna run the red light?
I try to,
Yeah. I think you're a farmer, what it indicated on here. What about the farming field? What kind of decisions do you make that you really want to predicate on the beyond a reasonable doubt standard if you're farming?
typically, you know, I'm making, say, for instance, I'm making fertilizer or chemical applications and there's a chance of rain coming and, I may, you know, if it's a high chance of rain, I would, possibly hold up on making an application, so I don't wash it off.
And would that be because of this, the danger that would be involved if the decision was incorrect? You want to have that level of.
It's a financial decision.
Okay.
And,
Which is important.
to that extent,
Yeah.
certainly.
Does anyone, I guess, to think of other examples in their own lives where they have decisions that they have to make, they would want to clock down beyond a reasonable doubt standard to give you an idea of what we could be talking about. Anybody else have any ideas? So, Mr. Grant, sorry. What do you think?
I don't have any that I.
Why do you think it's, do you agree it's a high standard? Why do you think it's a high standard? Why is it a high standard in the criminal case? It could just as easily be probable, right? Something else. You know, anybody have any ideas? If you're, love it, what do you think? Why is it? Well, first of all, you agree with this proof beyond reasonable doubt is a high standard, right? Why not make it easier for this board? That's pretty hard, right? Beyond reasonable doubt, I'm make it easier on this problem. They probably did.
Well, no, but she would have to have the proof to show that he did do it.
Well, if you're making the law, right, you're just, you know, dictator for the day, you want to change the seal, that's too hard for the state. Proof beyond reasonable doubt.
That's too hard to state.
No.
I see it, I see it every weekend.
Okay.
Right across the street from mine,
We're on what now?
people are so drunk they can't even stand up, and they're getting in vehicles and driving down the
So
road.
it should be dang easy for the state to make that
Oh, it
work.
should be really
Really?
for her, yes.
So you think this quarter's gonna have an easy time, I guess?
If they got the evidence, and I'm sure that they do, then it's gonna be really easy for her.
Well, how are you sure that they did?
Well, my son that works for the Jefferson County Sheriff's Department,
Mm-hmm.
and, They make them traffic stops all the time.
What do you
They
think?
do the field sobriety test, blood alcohol draws and breathalyzers. And so I'm sure that they got the evidence or.
Well, what if he doesn't show up?
Or he can be,
What if he doesn't show up tomorrow? They don't have a witness.
oh, I'm sure that fellow will show up.
I just found a felony, he got dismissed, or came down here, they did the same thing this morning, they didn't have a witness, he got dismissed.
That was,
But how can you be sure of anything?
I'm pretty sure that police officer was gonna show up.
Maybe, probably, you're probably right.
Probably right, yeah.
What about you, Mr. Mendoza, what do you think? That's a piece of cake for beyond a reasonable doubt.
I don't think it's a piece of cake, but I mean, as a possible juror, I mean, I want to see it.
Right. Well, just on the standard of proof of beyond a reasonable doubt, why not make it easy? Not just in DWIs, all these things. You got like serious cases where children are being sexually abused and there's tough cases beyond a reasonable doubt. Why not just make it probable? Because
It's not good enough.
why not? Well, I mean, I guess it's kind of for the grace of God, go high, and you have to be made, one of my friends or loved ones, accused of the case, and I would want that level of, it's not certainty, but that level of assurance that somebody not be wrongfully convicted and sent to prison because of what's at stake, right? What's at stake in a criminal case, ultimately, as far as punishment goes? Freedom, right? Sometimes life or death is a capital murder, but freedom, being able to, possibly being locked up. In this case, this is a class A misdemeanor, you should go to jail for a year. Right? Lose your freedom for a year in the Jefferson County Jail. And again, as I was talking with Mr. Fishman about that, that's an important thing. Freedom, and that's why there's this high standard of freedom beyond a reasonable doubt. Same as in your lives too, when you make decisions that you predicate on kind of proof beyond a reasonable doubt standards, same thing because of stakes, and that have either financial, maybe a surgery you're looking at, whatever it is. You all are familiar enough in your own lives to have an idea of the standard of proof that you be called upon as yours to evaluate the state's case. And I just ask that you keep that in mind as I ask you. What about all I have? I know it's getting late today. I want to give you all some time back. So I'm gonna go ahead and just sit down. Is there any questions that you have of me? Anybody? No? Mr. Swain, I got you. How much did that Odyssey system cost the county? They got you up here.
Beyond a reasonable doubt, it was over $2 million.
Yeah, how much did now? How much did it still cost the county? It's continuing.
And it will continue to cost. It has an annual fee.
And I'm not, it's not, what you're listening. We've got a new computer system. I tell you, it was gonna be unbelievable without standards. I'll get to that system. We better make that decision because it's been unfolding.
Yeah. It's a mountain decline.
Yeah. All right, thank you.
Ladies and gentlemen of the panel, we're gonna ask that you follow the bailiff out into the hallway. Now, we may call some of you back in to do some follow-up questions. So at this time, would you, everyone please stand as the panel exit the courtroom?